Hello, this video series may be of 5 or 6 videos on the subject of penology is the result of the motivation that I got from some of our dear students. The exams are coming up, and so I felt that I should be able to contribute my little bit in the understanding of the subject of penology. I am Dr. Vibha Sharma, Associate Professor, Government Law College, Ajmer. So let's begin. Reactions to crime have been different at different stages of human civilization. We all know that. And even at a given time, they have been different in various societies. It has rightly been said that the attitude towards crime and criminals at a given time in a society represents the basic values of that society. The attitude towards criminals has always been colored by extreme type of emotions displayed by the society. So here in this video, we will read the subject relating to this particular aspect of administration of justice. And in this lecture of mine, we would be seeing the meaning of penology, the introduction to the subject penology, its definitions which have been given by various authors, its object, and also the salient features of penology. So we all can very well figure out the meaning of penology. It is a study of punishment in its relation to crime. It is a science which deals with principles and methods of punishments. We can also say that it is a kind of sociology which deals with theory and methods of punishment. Those who commit the crimes on conviction are punished by the state. Therefore, it is evident that the object of criminal justice is to protect the society against the criminals by punishing them according to the existing penal law in the state. Thus, the punishment can be used as a method of reducing the incidence of criminal behavior either by deterring the potential offenders, by incapacitating and preventing them from repeating the offense, or by reforming them into law-abiding citizens. So therefore, it is the principle which underlines the doctrines concerning the desirability and objectives of the punishment. So as we know that the main objective is to protect the society against the criminals, and we find many theories of punishment in this regard. And when we look at the theories of punishment, we find that they actually contain general policies regarding handling of crime and criminals. The term penology was coined in 1834 by Francis Leiber, a German American, to denote a system of administrating punishment to the convicted offenders. But as you can see, Cesare Beccaria's essay on crimes and punishments, which was published in 1764, marks the beginning of what came to be known as, a few years later of course, a classical school of penology. Now, Beccaria's views on crime and punishment shook to its foundations the arbitrary, inhuman, oppressive, traditional penal system, setting in motion radical penological concepts and doctrines which provided a framework of more humanistic, more enlightened, and rational penal system. So, as an organized branch of knowledge, penology is only 2.5 centuries old. We can further find many works which was carried out by various authors, various criminologists, and jurists, which primarily deal with the work of prison reform, say by John Howard, Elizabeth Fry, Mary Carpenter from England, William Crofton, Ireland. All these people have actually worked to bring about more relevancy to the subject of penology. However, the principles of penology were for the first time enunciated in the United States of America in the Declaration of Principles of 1870. And in modern times, penology has shifted from a retributive-based punishment to a form of community corrections. So we can say that penology concerns with the various aspects of punishment and penal policies. The various mechanisms of punishing the offenders are also studied under penology. So it is actually an extended branch of law enforcement. The main justification of the penal mechanism lies in the overriding function of the state, and that is to maintain law and order, to sustain law enforcement mechanism, and maintain them in terms of condition. And therefore, when we see these definitions which have been given by various renowned criminologists or penologists, we find a reference to the punishment and also the way it is being executed. So, according to Francis Leiber, who is known as the father of penology, penology is that branch of criminal science which occupies itself or ought to do so with the punishment and the criminal, not with the definition of crime, the subject of accountability and the proving of the crime, which belong to the criminal law and the penal process. So here he actually demarcates and lays down the proper scope of the subject of penology. We can see that he calls it to be a branch of criminal science and says that it has to do with the study of punishment and the criminal. And it has nothing to do with the definition of crime, subject of accountability, etc., etc., because he considers that all this actually belongs to criminal law and the penal process. Then coming to Fairchild, we see that he says penology is that field of applied sociology which deals with theory and methods of punishment of crime. So we see a shift that he actually is saying that it is that field of applied sociology which deals with the theory and methods of punishment of crime. Dr. P.K. Sen puts it as penology ought to lay down the fundamental principles to guide the state or sovereign authority in framing of the scheme of punishment. So Dr. Sen actually has again slightly threw some more light on that and says that it actually lays down those fundamental principles which guide the state or the sovereign authority in framing the scheme of punishment. And coming to Dean J. Champion, another renowned penologist, he says that it is actually the study of theories and practices of punishment. Now, it is very interesting to note here that according to Dean Champion, prisons are also called penitentiaries. As you can see that I have put it in the bracket. Now, the word penitentiary was coined in the late 18th century because certain groups believed that through solitary religious study of the Bible, prisoners would become penitent, that is remorseful, and reform their behavior. Now, From these particular definitions, we actually have an idea as to what penology does. Now, moving on to another one. So this definition actually appears to be very long, but when we see it and read it, we will find that it is actually a very short one. So MS Subnis puts it as that penology is, at best, a body of systematized knowledge of management of penal measures and penal institutions. And then he explains that it is so designed that a minority among people who dare violates the established norms of individual and social conduct and behavior codified as law by a given society at a given time and place are kept out of circulation for a certain period of time in order to enable the rest of society, which is predominantly law-abiding, to constitute useful activity without hindrance. So if we understand the first two lines that I have underlined, it would very clearly bring this particular aspect of penology, that it is a body of systematized knowledge of management of penal measures and penal institutions. Now moving on to Encarta Reference Library 2005, we find that it says penology is the study of prisons and punishment management. It studies the theory, scientific study of and practice of how criminals are punished, how prisons are managed, and how rehabilitation is handled. And so, in view of all the definitions that we have seen so far, it can be said that penology is the scientific study of infliction of appropriate sentence on conviction of an offender and execution thereof in the form prescribed by the law. Now we also understand that the area of penology starts from establishing the conviction of an offender to guide the judiciary in inflicting appropriate kind and quantum of sentence, looking into the circumstances of the particular case, and extends to all aspects until such offenders return to society or are free from sentence which has been imposed by the competent authority. So therefore, penology is branch of knowledge and having practical bearings. It concerns with crime and punishment. And it can also be concluded that basically penology is that part of criminology which scientifically studies the treatment of offenders till they are free from imposed sentence. So invariably it includes theories of punishment, different kinds of sentencing of process, penal institutions, rights of prisoners, and all provisions relating to correction and social reintegration of prisoners. Okay. So now coming to the objects of penology, we very well know that the basic and primary object of penology is to protect the society against the criminal. This is the supreme object of penology. And how? It is by inflicting punishment under the existing criminal law. Thus, we find that the Honorable Supreme Court in M.H. Hoscott versus State of Maharashtra in 1978 observed that social defense is the criminological foundation of punishment. The court should not confuse between correctional approach to prison treatment and nominal punishment verging on decriminalization of serious social offenses. The first is basic and the second is pathetic. That court which ignores the grave injury to society implicit in economic crimes by the upper berth mafia ill serves social justice. Soft sentencing justice is gross injustice, where many innocents are the potential victims. Then, when we see the objects of penology, we find that administration of penal measures is also one of its objects, because penology is concerned with the administration of penal measures and penal institutions. We have already seen in the definition also. So now we find that the chief aim is protection of society against the depredations of the deviant, which is also its social purpose. Now, within the framework of the concern and that purpose, penology has devised various mechanisms composed of the rules and regulations, procedures and activities which are opposed by the state, the mechanisms that are essentially intended to serve the ends of the prevailing criminal justice system as the more dominant section of society sees and dispenses it at a given time and place. Now, coming to the next one, that is infliction of appropriate punishment. I have brought two cases here, and they actually are slightly different from each other in what they convey. The main object of punishment is to make it appropriate and to balance it so that it justly fits the gravity of the offense. So we know that one of the objects of penology is infliction of appropriate punishment. Now, regarding this, in Ayub versus State of UP, it was held that at the same time, the punishment inflicted should not be such as to shock the public conscience and thus warp and dull the public social sense and appreciation of crime as evil. However, in Marudam versus Union of India, Justice Fazl Ali said, of course, in his concurrent judgment, that the problem of penology is not one which admits of an easy solution. The argument as to what benefit can be achieved by detaining a prisoner for 14 years is really begging the question, because a detention for such a long term in confinement, however comfortable it is by itself sufficient to deter every criminal or offender from committing offences so as to incur the punishment of confinement for a good part of his life. The effect of such a punishment is to be judged not from a purely ethical point of view, but from an angle of vision, which is practical and pragmatic. So yes, now after seeing the object of penology, we come to the last aspect of today's video lecture of mine, and that is salient features of penology. I hope that you all are aware that D.R. Taft is an eminent criminologist of his times, and he actually has enumerated some of the salient features of penology, and according to him, penology is a technique of punishment and reform of criminals. It is the function of the criminology to formulate affection and construction technique to keep and maintain social peace and security. The aims and objects of these techniques are to suppress crime, of course. Penology helps in establishing and managing the institution of reform, probation, and correction. And he says that besides helping the reform of criminals, penology also helps in bringing about social harmony and peace. And lastly, penology formulates and applies certain collective principles for the reform of society in general and of criminals in particular. So I really hope that this particular lecture of mine helps you in understanding penology a bit more. Yes, exams are coming up. All the very best to all of you. Please take very good care of yourselves. Good luck and thank you.